Hi, Mark. Good to see you. I've been seeing a lot of interest on my LinkedIn feed about a possible ban on upwards only rent reviews. What's going on?
Well, John, it is interesting, and it came as a bit of a surprise. We didn't get the normal sort of consultation, white paper. You had to be reading the English Devolution and Community Empowerment Bill, get all the way to Schedule 31, and then suddenly realise that the government had decided to try and stop upwards only rent reviews. Um, Now, it's a surprising idea, but it's quite a simple one, and you can see very much where it's coming from. The idea is for business tenancies, so linked to the 1954 Act, anything that would fall within Part 2 of the Act, whether or not it's going to be contracted out in the end, all of those tenancies, you basically, as a landlord, have two choices as to the sort of rent review you can have. You can have something that's a certain increase in rent. So it could be just a stepped rent of 1% a year, or you could have a formula. So you could say on the fifth anniversary, it goes up by £1 a square foot. As long as the tenant can sit at the start of the lease and calculate it, then that's fine. And those can be guaranteed to go up. Or if you want something that might, depend on something like market rent or indexes like RPI or turnover, it's fine, you can still have those, but they have to be able to go up as well as down with the index. So you can't have any kind of collar that stops the rent falling below a certain level, even if the collar's below the passing rent. So the idea is either everybody has certainty or everybody's exposed to the vagaries of the market. It's not going to be retrospective. So this is looking at tenancies that are going to become binding after the bill becomes an act, if it ever does. And the other thing that they've definitely thought about is you might think, well, landlords are just going to avoid this by not triggering their rent reviews. Well, there's some provisions in there that the aim seems to be to allow tenants to trigger landlord only trigger rent reviews, so that if they want to, they can make the rent review happen and say become adjusted to the market again. So that's the basic idea. It seems sensible. Obviously, we're not at the final versions of the proposals yet, but definitely something to be aware of.
It's interesting. I've wondered whether, actually, as drafted, whether the provisions meet the policy goal, which is presumably what the government wants to achieve, is to avoid business tenants, and in particular, I'm guessing retail tenants, are being stuck in over-rented premises where there's been a fall in rental values, which is not reflected in their rent, and they find themselves paying over the odds and unable to assign their leases. But the only way you can actually achieve that is to ensure that rents can fall in line with falls in the rental market. And as you said, Mark, the Act will allow, if it's enacted in this form, will allow stepped rents, and it will allow rents to be adjusted by reference to an index like RPI, or some more sophisticated index. And in either of those cases, you're going to have a rent which is not in line with the property market necessarily. Step rents obviously provide certainty for both landlord and tenant. Everybody knows where they're going, but we can see from cases like Arnold and Britton that over a long period of time, embedding those kind of increases can be problematic. And it seems a bit out of kilter with what the government's been doing in the residential field as regards ground rents, where they have prohibited those kind of escalatory ground rents. And an index like RPI or CPI, obviously a lot of leases already have rents increased by reference to those. It seems quite innocuous. But inherently, you're pegging your rent for property by reference to something which is not property. You're pegging your rent by reference to a basket of goods, which the value of which bears no resemblance to the property market. And so inherently you're creating a situation where the property market might fall dramatically, but RPI, CPI are actually likely to rise. That's been the general experience. So you do end up with the same problem that the tenant is paying more than the market value for their premises. I guess you could look to more specialised indices, something which attempts to track actual property values. But I would have thought a bit of care's needed. I mean, is the rent for a barber's shop in Preston going to be fixed by reference to an index which includes shops on Regent Street? Well, if it is, then the barber's shop in Preston is likely to end up over rented as well. And we've seen from LIBOR, for example, that there is the risk of abuse or indices being skewed. They might not have a sufficiently broad and robust base to be really reliable. So not at all straightforward, it seems to me.
No,
Anyway, Mark, sorry, go ahead.
no, no, I really agree. I think that you're relying on both landlords and tenants sort of being very transparent and open with each other, and that may happen some of the time, but it's probably not going to happen all of the time. And I think there's also some potentially interesting thoughts for property litigators of disputes that might come up. I mean, rent review disputes, obviously there are plenty of them around, but they're on quite narrow basis. Most of the legal points have been decided a long time ago, but this could really kind of reignite some new interesting thoughts. There were two that came immediately to my mind. The first is that this schedule starts off by saying this whole schedule only applies to you if these four conditions are met. The first condition says it's a tenancy to which Part 2 of the 1954 Act applies. And obviously, for that to be the case, you've got to have a tenant in business occupation. Now, you could have a slightly strange situation where a tenant's in occupation, and so they're protected by this act from potentially onerous rent review, and then perhaps they sublet, or perhaps they are coming up to a break clause or the end of the lease and they want to make sure they give VP, so they clear everything out a few weeks early. Well, if you were being a very sharp landlord, you might hold off on triggering your rent review, wait for the tenant to do something like that, and then suddenly jump on it and say, well, you're no longer protected by the Act, which means this whole schedule doesn't apply, which means that now I'm going to have my, upwards only rent review in the way that I wanted. So obviously that is going to depend on facts, and we know from the 54 Act debates about occupation are being fought over, but there's there's potential there. And then you might think, well, Mark, that's not going to happen because the tenant can trigger the rent review. That's what you said. But there's a bit of a curiosity in that as well. But what it actually says is if there's a trigger that's needed to trigger the rent review, then the tenant can trigger it, even if the lease says only the landlord can, by just giving notice in writing. But I mean, it may be that the drafting changes here, but at the moment, what it says is that tenant's notice may not be given after the time when trigger action may be taken. So if, say, the landlord has to give 6 months notice to trigger the rent review, then we know that time isn't usually of the essence. The landlord can sit on that, not trigger it. And on this reading here, once the deadline for the landlord's trigger has gone past, the tenant is kind of locked out. So the tenant would have to take a gamble as to, well, what are market conditions or index going to be at a date in the future, whereas the landlord can sit and wait and trigger it retrospectively once they know the answer. Doesn't seem entirely fair, and that's one thing that I think might get tweaked a little bit. And of course, all of this assumes, as you were saying earlier, that the landlord doesn't try and do something very clever with indices and in the first place. I think you've seen some interesting ideas floating around about that.
Yeah, it's not a surprise to see that people are already looking for kind of structures and workarounds that might preserve effectively the benefit of upwards only rent reviews. And certainly one that I've seen discussed is the idea that you could have a rent review to the higher of an open market rental value or an RPI, CPI index. So that's obviously worse for the tenant than an upwards only rent review, because not only does it have the characteristics of an upwards only rent review in the sense that the landlord gets the benefit of the market going up, but the tenant doesn't get the benefit of the market going down. The floor is not even the passing rent. The tenant has to pay the rent plus the RPI increase. Is interesting, and I don't doubt if and when this is enacted, there'll be lots of thought given to different ways in which effectively it might be got around. I mean, my feeling about it is these sort of structures are all very well and interesting, and they might look good when you just apply the provisions of the Act literally, as it were, but whether they'd survive a challenge in the Supreme Court is a different matter, because you are fundamentally undermining the entire policy on which this legislation would be based. So might be some interesting work for us as property litigators if those mechanisms are tried out.
I really agree. And, they've put in some anti-avoidance wording, but at the moment it's just very narrow. It's just focused on paying penalties if if you trigger the rent review clause. And I think, as you say, either through the courts or through, strengthening that, probably if this is going to achieve its aims, it's going to need to be toughened up a little bit. But that's what property litigators are there to argue these things out.
Yeah, absolutely. And we enjoy doing it, don't we, Mark?
We do indeed.